Hello, my name is Jeff Gottlieb. I'm a special needs attorney located in Southern California. Today we're going to discuss the issue of regional center eligibility. Now, if you need more information, feel free to give a call to my office at 562-699-2412, or you go to my website at www.specialeducationattorneyatlaw.com. That again is www.specialeducationattorneyatlaw.com. Phone number again is 562-699-2412. This YouTube video only allows for about 10 minutes of time. So what we're going to do is we're going to have you move along very fast and give you a lot of information. So to help facilitate that, I usually don't use prompts, but today I'll have this tablet here to give me a hand. Anyway, to begin with, I'd like you to be able to find a resource for further information. So I recommend that you go to Disability Rights California, simply Google Disability Rights California, and go to their publication on the Lanterman Act. Disability Rights California is a not-for-profit advocacy organization that serves individuals throughout the state of California. Again, that's Disability Rights California. Go to their publication location. If you can't find it, then go to my website, and I happen to have a link to their organization where you can find the publications. Well, the reason I raise the issue of publications is you need to be as educated as you can be even before you request an intake session on behalf of your child, what's called a consumer, for eligibility determination. That will help you increase the likelihood that your child will be found eligible for services through the regional center. Okay, first of all, in order for your child to qualify for regional center services under what's called the Lanterman Act, your child needs to have had a disability before the age of 18, and it must be a substantial disability. Before the age of 18 goes to the issue of a developmental disorder. There are 5 categories in which your child can be eligible. If your child does not fall into one of these categories, almost always your child will be found ineligible. The 5 categories are autism, cerebral palsy, epilepsy, mental retardation, and conditions that are similar to mental retardation. So if your child has those characteristics of those conditions, then your child can possibly qualify for eligibility. But there's more factors that go into eligibility than just any one of those 5. And it only needs to be one, even if your child has more than one condition. So again, that's cerebral palsy, autism, mental retardation, epilepsy, and conditions similar to mental retardation. In addition, and this is critical, in addition, your child must have one of the 3 challenges in areas of deficit. That is communication, receptive and expressive typically, but can be one of them. Learning abilities, mobility, self-direction, economic self-sufficiency, and independent skills for living. Again, those are communication, learning abilities, self-care, mobilities, self-direction, economic self-sufficiency, and independent living. Years ago, it only needed to be one of those areas of deficits. You must be able to demonstrate a substantial disability in at least 3 of those areas. So if a child has autism but doesn't have any of those characteristics, even if the child has autism, the child will not be determined to be eligible for services. Okay, so the first thing you need to do is request an eligibility intake. So you need to put that in writing. You need to contact the regional center and make a request to determine whether or not your child is eligible for regional center services. I'm going to read to you the information that you should bring to that meeting to help them find eligibility on behalf of your child. One will be clinical records, medical records as an example, any psychological evaluations, all school records. You're going to want IEPs and assessments, and you can pick which of the records you want, because you may have some records that don't help you or actually go against what you're trying to prove, so only bring those records that will help prove your case. The other thing is that you may want letters from clinicians, family members, neighbors, as to the attributes of your child, such as issues of independence, inappropriate behavior, whatever it may be that will help buttress your case. The other thing is you need to make certain that you have some test of adaptation skills, behavioral skills, where your child has significant deficits. Subjective would be observations. Objective would be a test. So you probably want to make certain either from the school district or elsewhere that there have been some type of adaptive behavioral assessment of your child where findings have been determined that will help you prove your case. Anything else you may have, if your child has had an encounter with the police because of, let's say, inappropriate behavior, that would help you. So again, it's going to be clinical records, psychological evaluation, school records, IEPs, assessments from the school district, results of adaptation skill tests, as well as any letters from clinicians, family members, neighbors, whatever else may help you. Now, if you're turned down for eligibility, which will typically take place within 60 days of the intake, then you need to file an appeal. And I don't want to give you the time frame for that because it changes. Just read the documentation that you have, and the regional center will tell you how many days you need to file an appeal. I recommend you do it within 7 days or less of receiving a denial. Now, in order to prepare for a hearing, you can use the same information that you use for the intake. Now, sometimes you may have done your own psychological evaluation after the denial, so you'd want to use that as well. But what you need to do when you go to a hearing, you need to make certain 5 days beforehand that you've given them a list of the witnesses and all your exhibits. Your exhibits would be exactly the same things I went over before. Clinical reports, psychological reports, any assessments, any IEPs. You also need to know what witnesses you want to call. And you have to remember, every piece of paper that you have as an exhibit must be there to prove a point. If you're trying to show that your child has communication problems, you want documentation from clinicians and other people to show that. If you call witnesses, you need to know exactly what questions you want to ask those witnesses to prove a particular point. You do not have documentation for the sake of documentation. You do not have witnesses for the sake of having a witness. Every question, every document has to have a purpose to support your case. The other thing is when you go to the hearing, what you want to make certain of is you have an exhibit binder. You want to have one binder for the judge, one binder for yourself, and one for your witnesses. Now, you should have given an exhibit binder to the regional center before the hearing, I believe, at least 5 days, because 5 days is the typical time frame. So I would recommend 10 days before the hearing, you give the regional center all your exhibits. The other thing is you need to make certain that you subpoena all your witnesses so that they will appear. You have your questions ready. You have an opening statement addresses what you will be addressing at the hearing. And lastly, if you have to go to a hearing, you're going to have what's called a closing argument. Closing argument is where you bring everything together. I highly recommend that you request of the judge that your closing statement be allowed to be in writing within 10 days after the hearing. That gives you time to think about what you want to say, because it's quite often difficult at the hearing to actually say everything you need to say. Anyway, that's what I wanted to give you very quickly through this YouTube video. If you have more questions, feel free to give a call to my office, 562-699-2412. Thank you.